All right, everyone, we're going to go ahead and call the March 12 Planning and Zoning meeting to order. Before I do, just for us, we have members of the public. If you come up to speak on different items, you're going to need to state your name and address. That's part of the procedure. And we have people listening online. That way they can see who's identified. So we'll go ahead and begin with a roll call. If you'll do that, Tammy, please.
Ms. Logan?
Here.
Mr. Adams?
Here.
Mr. Van Arsdale?
Here.
Mr. Kerrigan?
Here. Okay, thank you. All right, the first item on the consent agenda is the minutes from the February 2, 2026 P&Z meeting. Has everyone had a chance to look over those minutes?
Yes, and I have a question for
Okay.
Tammy. Down near the bottom of the first page, it says, Ms. Logan questioned the adequacy of a 10-year time frame, and then it continued. There was another sentence following, while Lisa Logan noted that they can blah, blah, blah. I have to question, was that me? I don't remember making those comments at all. Could be wrong, but I'm 99% certain I didn't say that. I have not had a chance to go back and look through the tape to try to find this section so I can verify it, but
Let me find where.
I just questioned that I said it.
It says that the PUD section that was in the 2014 LDC edition, is that what you're talking about?
Down below that, yes, there are a couple of lines down. It says, all agreed with reviewing both copies before making any recommendation. Mrs. Logan questioned the adequacy of a 10-year time frame for final development order approval, noting potential market uncertainties and external events. And then a couple of sentences later, it said, Jack Kerrigan expressed concern that the 10-year requirement could deter developers, while Lisa Logan noted that Bay County does not have such time limitations. I'm simply saying,
You don't remember? Okay, I'll go back and review it.
I'll try to go back through it too, but just put a question mark
I
on
sure
that.
will. I'll go back and review it.
Thank you very much.
Any other questions on the minutes? Would someone like to make a motion to accept them and knowing that Lisa entered a comment which is going to be researched?
Okay.
Well, there's no requirement that you do it. Would you rather have that research done before you approve them?
Let's do that. Yeah.
Okay. Then we'll review the minutes at the next meeting?
Correct.
Okay.
Thank you.
All right, then we will move on beyond the minutes to the regular agenda. Now, this is consideration of changes to Article 7 of the Land Development Code, appeals, concurrency, hardship relief. Laura Mills Gutcher, if you will come up and, or you don't have to come up, I think you can take it from where you are, but if you'll take us through this, please.
Absolutely. Yeah, so continuing on with the review of the Land Development Code and the amendments, accordingly, you're looking at Article 7 tonight. And just because there's been a lot of fast movement today, I want to explain what you have before you. What you received in your packet via email, I suppose, earlier this week was my recommended changes, proposed changes to you. This afternoon I did receive some comments from Tim and reviewed them briefly. I think there was an initial email conversation about putting his changes to you in addition to mine, but when I looked through them, I was afraid it would be a little confusing trying to compare two different versions of the same changed document. So what I did was try to incorporate as much as I could. And I'm going to disclaim I probably didn't capture everything he wanted to include, but what I could into the document that was handed out to you tonight. So you will see a version with red, strike through, and underline, and then a version with, and then in that version has blue font also. And that blue font is what I gleaned from Tim's comments in the primarily section 7.03.00 and the subsequent sequences. So with exception to the variance section, which we'll talk about in a little bit. But just so you know, that's where we are with the document you have on the table tonight. So if you'd like, we can start with the first page, section 7.00.00, which I don't believe Tim had a comment to. And then go through accordingly, and as we need to, we'll get Tim to help explain
Okay, that's what I was gonna ask.
some of that as well. So on the first page, Article 7 to be renamed Appeals, Hardship Relief, and Concurrency, because those are the three topics of the article. We before realized we didn't have a variance section, or maybe it was somehow omitted unintentionally. The variance section was included in this article, so adding hardship relief, which is the variance section, to the title. Then just some minor cleanup of the purpose and intent there, and I did notice I do have a typo that as long as I have liberty to fix typos, I can fix that in the first sentence, the first paragraph. And then from there, you'll see there's a lot of strike through for several pages. This is the section that will go into the new article for the development order review process. Because it is pretty extensive, I think it needs its own section, and it's not really an appeal or hardship or a concurrency issue. So it's a development order approval situation, so I would like to move that to its own article.
Well, except to the extent that the administrative appeal of the staff approval should also go with that process. So the 70301 that I was working with is to address really the staff approval, and so wherever you put the ultimate development review process, I would suggest that you also include that process in there. And then and the variance process is also often part of the development review. You may want to put that with it also, so the numbers may change.
Well, yeah, that's certainly something to discuss. The variance procedures typically precede the development order application, because you need to know you're going to get the variance before you hire someone to draft your site plans. You don't want to have to pay someone to draft your site plans and then know you're going to get a variance and have to go back and fix it. So usually the variance comes first.
You must be dealing with better organized owners and developers than I have seen. Usually
Well,
they
you
show
just-
up at the same time with those things. But anyway.
Well, you don't know you're going to get the variance. That way you're gambling you're going to get the variance.
Yeah, that's true, but that's often when I see one. Anyway, go ahead, I didn't mean that.
Okay, yeah, no, usually, in my experience, it's usually separate, because not many local governments that I work with will let you apply for them at the same time anyway. Usually you have to get the variance before you can apply for the development order. So that when you're reviewing, you know you have the variance.
Let me ask you something about what you said just a couple of minutes ago. You had said that the variance section was missing? Was
That's
this-
right, remember we had to adopt it, I think it was 2023, was that ordinance?
Yeah.
Yeah. So it was included in this article, so prior to that, we didn't have hardship relief in the title. So it's being added now.
So the section on variance was not missing, you're just saying that something called hardship approval was not in there? Because we had sections on variance before. I mean, it's always been in there.
I think you just
I'm
added it
not
to the
following
title,
what
weren't
you're
you?
saying.
Yes,
You just added it to the title.
yes.
Just
Just-
add it to the
It's
title.
in there, it's just not in the title, but because it's a part of this article, I think it needs to be in the title.
So only the title is changed.
Okay.
Well, we'll get to the variance section in a minute, but yes, I recommend the title changes to include the variance relief, the hardship relief.
And the yellow highlighted section, like on the first page, does that have some,
That's the version that they didn't get, Tim, so
okay,
we'll have to.
okay. I got too many versions apparently.
So the version that Tim sent out today had some recommended changes, which is what I tried to incorporate, and that's what you see in the blue. I didn't include contemplated by section 7.02.02A because that section is moving to its own article.
But even what you sent me this afternoon has yellow.
Okay, I see what you mean. I'm looking at this yellow that you had on
No,
your
no,
version.
no, I'm looking at what you
Okay,
have provided. to
yes,
P and Z.
yes,
And on page one, there were things highlighted in
yes,
yellow, but I didn't understand what those, the
yes.
highlighting meant.
We briefly talked about that last time until we decided to move this one to this meeting, but those are the items, the definition, so all of the definitions got moved to the appendix. So we have an appendix now that covers most of these definitions. These 3 highlighted definitions did not get moved to the appendix, because I feel like they're self-defined, but if anybody feels strongly about the first 2, I can certainly include that in the appendix. I don't believe we need to include development permit because that's defined by Florida statute. And we have a clause in our appendix that says if it's not defined here, we defer to the Florida statutory definition.
We have so many versions and so many colors. If you'll
I know.
state the page that you're on, I know we're gonna
Okay.
do more of this, that might help.
Tim is talking about page 7-1 of the one you received in the email.
Okay.
And that is the one that has the highlighted definitions. The first one being certificate of concurrency, the second one being concurrency, and the third one being development permit. Those are the definitions that did not carry forward to the appendix.
And for convenience, Mr. Chair, at the bottom, I think Laura's got draft 3/13/26 at the bottom.
Okay.
Of the one that they received just this afternoon, yes.
Okay, let's see that. All right. Thank you.
So my recommendation is not to move this forward to the appendix, specifically, or certainly not development permit, because it's defined by Florida statute, and we defer to that definition. If it's defined by Florida statute and we define it similarly, and they change the definition in Florida statute, then we're not consistent with Florida statute. So if Florida statute defines it, I'd rather defer,
And that's the pattern we've been following.
Yes.
It's defined by the Florida statute, we're going with that.
yes.
Okay?
So certificate of concurrency and concurrency itself are also not carried forward into the appendix. Concurrency is actually also defined by Florida statute. It's got its own section of the Florida statute. I think it's 380. So I would defer to that definition. If you want to include certificate of concurrency in the appendix that we have in our code, we certainly can do that. Just need your direction there.
Could you not reference the statute as maybe amended or superseded?
Well, we do in the appendix, because we say we defer to the statute if it's not specifically defined in the appendix. So it already says that. The following definitions are for clarity during the interpretation of this land development code. If a definition is not included herein, Mexico Beach shall defer to any Florida statutory definition as applicable in the appendix. That's in the appendix.
Is everybody okay with that? Yeah. All right,
Okay.
thank you.
So, this is the tricky part because we're gonna move into section 7.03.00, which is on page 7-15.
Thank you.
And so at this point forward, I'm gonna try and talk about both sets of comments.
Okay.
And if I get a little confused, Tim, you're gonna need to help me out too, because, it got a little,
So question, who's in blue and who's in purple?
so it should be blue and red.
Yeah, I've got red and purple on mine.
Yeah.
Yeah. I think mine is purple.
I think it must just have been the way it printed out then. So it's red and blue or red and purple, whichever you
Okay.
have. The blue is, or the purple is what I tried to take from Tim's comments, if that's right,
Okay.
and put it in. So it's dragged from Tim's comments.
Tim Theodore.
Yes. June.
And I have not had a chance to look at what she's tried to incorporate. All I did was just prepare those two sections.
So on the first, section 7.03.01, administrative appeals, this is an appeal to a decision made by someone at the city staff level. So it could be now, it could be a plat, because now the plat has to be approved by city staff, or it could be some kind of sign permit or something that doesn't go before a board. This is an appeal to a city staff person's decision.
Where 70202 moved those sections that I referenced, that I thought it needed to be clear that those were the ones that could have an administrative hearing, because the major commercial would be decided by the council.
But it's not gonna be just that, because it could be a sign permit. It could be other kinds of permits that are issued, not just a development order. It would be any decision that the city administrator or designee can make.
I'll give you some language on that then.
A question, and I have brought this up multiple times over the years, but I continue to bring it up. It says administratively approved by the city staff. And I always ask, especially when it comes to determining building regulations, who are the city staff who are involved in these decisions? Because our staff, in my opinion, does not run to a city staff that is supposed to be involved in this. So who on the city staff, other than a contract city planner when they're brought in, who on the city staff is involved in these decisions?
So ultimately, I'm not issuing any development order. It would be Mel. I might write the opinion, I might write the order, but he is issuing it.
That's what I said, when you were brought in to consult on it. But other than that, city staff.
Well, you're talking about the building side, which is EPCI.
Well, I'm talking, okay, long
And-
choice of words. I'm talking about when people are deciding anything about the land development regulations. Who is the staff?
Well, the city administrator, I think, determines the development permit side. He's the ultimate buck stops here on the development permit side. But I don't think you are reviewing the building permit stuff, are you?
I don't review the building permit, right?
Right.
Right.
So one of the things that the reason I wrote some language in there about building permits is because Greg is making interpretations and dealing with the building permit side. And as far as I knew, there was no specific appellate process to review his stuff. So that's why, Laura, put in the development order or development permit, whatever you want to call it, or a building permit, because we need to provide the public some mechanism if he makes a decision and they don't like it, what they can do about it. We need to at least provide that somewhere, and that was the easiest place to put it. But if we don't put it there, we need to put it somewhere so that people know, hey, if EPCI doesn't issue a permit and I want to contest it, how do I do that?
So, and I'm not sure, I don't get into the building permit part of it, that's way past me, so I'm not sure how an appeal to a building official's decision is made, but that's generally not a land development issue, that's a building permit issue, and that goes into the next tier of things from the land development code.
Right, and I was just trying to, at least in the near term, address it as an administrative process, that there was some review of that decision on an administrative level. And then ultimately, if it is reviewed and the applicant or appellant didn't like it, then they could ultimately go to the circuit court and appeal that decision, but providing an administrative remedy, kind of gave the council the ability to come and look at what he has done, on the building permit side.
I personally am fine with that. My question was a little bit over to the side, and I'll just not go into my question anymore. I agree with what you've got here. I think there needs to be some sort of an appeal process, because, and over the years, the land development regulations have been where people go to get their information. I know a lot of it is now being shifted over into the Code of Ordinances, which in some cases I agree with, in some cases I don't. But ultimately, the land development code is where people go, because in people's minds, at least historically here, things like this belong in land development. We don't differentiate quite the same way as Alara does. So, Alara, sorry. I like this in it.
But if it needs to change, we shouldn't keep it the way it is just because that's the way people are used to looking at the code historically. We should evolve it the way it should be evolved.
Agreed, but I think in this case, this is an appropriate place to put it.
Well, our question, since it's pretty vague, and it's any written decision or order made by a city staff person, in the future, the council might decide that a staff member makes a decision on something that is in the LDR. So is there any harm to it?
The is, or did you say is or isn't?
Is there any harm to it remaining?
I don't know that there's any harm, but I think organizationally, so I'm looking in your Code of Ordinances and I don't even really see anything in here about a building official. So that's where I would have put it. If there was a section in your Code of Ordinances about a building official, how they operate, that's where I would put it, but I don't
Well,
see
not just specific to a building official, but just any decision that, do we have anything in our code that already lays this process?
You mean like if a public works director makes a decision about where the pipe is gonna lay or something
Yeah.
to appeal?
And somebody doesn't like it?
To my knowledge, there's not, and typically you don't ever have an appeal, administrative or otherwise, of that kind of decision, because ultimately, if it's not a decision where they've done an application and gone through a process, then you wouldn't see an appeal. Buck's, again, gonna stop with Mel's position as city administrator. He might be called in at a staff level to review whatever Public Works has said,
So
but it's not an official process.
So your legal, on the stuff that people apply for and they don't like the result, is there something in the code that already deals with this? Or
Not that I'm aware of. And
where do you think it should go as the city attorney?
well, typically the land development code would be where you would put it, because it again, when I looked at it originally, it was looking at specific sections of a development permit application.
Okay.
I hadn't broadened it out to signage or other stuff, but I also was putting a quick fix in there relative to the building permit side, because that wasn't anywhere.
Right.
And I thought that at least we could, on a short-term basis, have it in there so that we addressed something that was otherwise silent. And the other thing to remember is that when someone is appealing a process, or when someone is going through the other process of, coming to P&Z and then to the council for approvals of, say, the major commercial stuff, interested parties are allowed to intervene. Now, the determination of who can be an interested party has been the source of a lot of litigation. If you live down the street and you just don't like it, that may not qualify you as an interested party. If you live next door and you're getting the stormwater runoff, that may qualify you as an interested party. So they have a dog in the fight, so to speak, and they would have the ability to participate and intervene in certain kinds of administrative hearings. And so I tried to accommodate that in here a little bit.
So maybe to help solve that, and we just state a development order or permit on that first paragraph, a development order or permit administratively approved by city staff or the building official, because the building official isn't necessarily city staff.
Well, and I think you should at least address the building permit side, but I have written a note, city staff or building official, including but not limited to those permits contemplated by, and those sections I knew were changing, so I didn't know where they were going. That's why I highlighted it in my draft, because you were moving them, and I just didn't know where you were putting them. But suffice it to say, the intent of this is providing a mechanism that somebody who feels they were aggrieved can pursue an administrative appeal prior to having to go file a case in circuit court.
So it sounds like we need to work on that paragraph a little bit before you all see it and make a decision, because there's a lot of tweaking that needs to occur without having to wordsmith it here live. We can bring that back.
Okay.
Does that sound,
So 7.03.01,
that first paragraph?
you and Tim are gonna work out.
1 and 2,
Okay.
which would be just a simplified version of what they get to do after the council's looked at
Okay.
it.
All right.
So are you saying then we're not going to go through section 1 or 2 at all tonight?
Well, I think what I just heard was that you and I are gonna get together and work out that specific language. There's a whole lot of other stuff in here besides that one section. You're bringing back a good number of things to the P and Z anyway,
Yep.
so my recommendation, we'll get it back to you in a form consolidating what I have with what she originally proposed.
So would that be at the April meeting?
Yeah, it could be. When's the April meeting?
The 6th.
The 13th.
I'm sorry.
13th? Yeah, that'll be plenty of time, I would think. Is that enough time for you, Laura?
It is. Can we meet tomorrow?
I've got some code enforcement orders I've got to write for tomorrow. Next week, next Monday or Tuesday, would probably be better.
Okay.
Well, then that takes us all the way down to hardship relief, section 7.04.00.
Oh, let's go ahead and open it up to public comment if we have a request.
Come on up, please.
John Harrell, 43 First Street, Mexico Beach. This is still in 70301. I have a question. It's 01. Number 5,
Is it part
we're at 70301.
B?
It's under B, yes ma'am. B, number 5, order proceedings.
Okay. The staff?
That's how it starts, right?
Okay.
My question is, it talks about all witnesses shall testify under oath. The mayor shall determine the admissibility of the evidence. Is that not going against our charter, where the mayor is just one of 5? He conducts the meeting, but they're all equal now? He is not the lone decider?
Well, typically you have a single person to rule on evidence, only because getting a collective agreement among the council every time there's an objection would make the process very unwieldy. So,
And that's why we changed the charter the way we did, because of that very fact. One person made the decision. And you may have 2 or 3 that object to that decision as far as like admissibility of evidence. So I'm just wondering, is that going against
Well,
what we-
Laura and I can look at it, I don't
What
have
does the
that.
charter language say exactly?
It says that all 5 are equal voting members now.
Well, and
The
that's
mayor,
not
the
changing
mayor
that.
runs the meeting, but he doesn't have,
Specific.
We'll take a look at that.
yeah, that was my only question. We spent, I don't, and Lisa was there, we spent, I don't know how many months going over that, and there was are we gonna be an administrative, are we gonna be a city manager? Is the mayor in charge? Because it was indicated by Mayor Kathy and Mayor Miller that they were the one. They were the chief financial and,
Well, that's a different animal than what you're talking about, but
Is it
we'll
though?
look at it in the context of an administrative hearing.
okay. That was my question was, because I thought we had spent so many months on that, would that affect it? And would somebody bring that up in an appeal if it doesn't go their way? And
I'll take a look at
thank you very much.
Okay. Bring us back to where we started.
704.00 hardship relief.
Okay.
So Tim rightfully requested that we delete that first paragraph because we did move that up into the section prior. So any appeal to a decision made by city administrator or city staff will go into that appeals section prior, so that should be removed. I agree. So I really didn't touch this section because we had just adopted this, I think it was in 2023, sorry. So I didn't really propose any amendments accordingly. But Tim has a few, and I don't know if we want to discuss that now, Tim, but,
Yeah, but, just to give you an understanding of my concept was, I wanted to tighten down the objectiveness of the council and not make it so subjective on the issuance of variances. When it's subjective, then people have a potential of saying, well, yeah, you did this, but you could have done this. I wanted to make it more objective, and that's why I have a bunch of criteria in here for how the council makes a decision. The other thing is, from a variance standpoint, I added language in here about, it was originally in here that you couldn't vary the comp plan, but, and the zoning map, but I wanted to also make it clear you couldn't change the National Flood Insurance Program language. And you couldn't require, that an ordinance be passed, you couldn't change densities, you couldn't, anyway. I just threw in some additional language on that. So again, from that standpoint, because Laura really hadn't had a chance to go in detail and look at what I did, she and I can get together, but the substance of it is over on my page 4, page 5, where I'm outlining those objective criteria.
yeah, and I do want to have a conversation with you about that because I don't think the context is really, I think the context is very, very similar, if not identical. It's just the way it's worded.
Yeah. So we'll get together on that, but the way the language read to me when I first read it, and I think I even commented to Mel about it, was that the city almost had the burden of showing that they did not meet the variance requirements, and that should not be the way it is. It should be the applicant has the burden. And it's not just a burden of proof, but it's also a burden of persuasion. So not only do they have to meet the test of the proof, but they also have to be the one to meet the persuasion to convince the council to do something.
Well, it does say the burden's on the applicant in here.
But anyway, those were the only 2 sections I had comments on. I did not have, I didn't get a chance to go through the rest of it. So if you'll give us a little bit of time, we'll bring them back in the April meeting and be able to go over that with you.
Okay.
Okay, so that brings us to concurrency.
What page?
So that's 7-20.
Okay.
So you deleted or moved this section on board.
Because it moved to chapter section, article 1, which we've already discussed. So concurrency determinations, so what concurrency is the determination that the services or the capacity of a roadway is in place at the time a development is finalized. It's required by Florida statutes to look at water, sewer, stormwater, and solid waste. Roadways is an optional concurrency determination. You can use that as a tool as a local government, but it's not required by Florida statute like the other 4 I just mentioned are. So I used that in looking at your concurrency section and made some amendments accordingly. I took some of the parameters that we adopted in the comprehensive plan. I moved them forward here into the LDC so that they are mimicking what the comprehensive plan says, such as the potable water standard, which is 250 gallons per unit per day at 40 pounds of pressure per square inch. That's exactly what it says in the comprehensive plan. All of these parameters, all these concurrency level service standards were moved from the comprehensive plan into, not moved, but copied from the comprehensive plan and put into this document. So it's not anything new.
The one thing on 721 about the validity of the permit or certificate of concurrency, I would like to consider
Can you tell me exactly what section you're talking about?
in number B up there.
Are we on page 7-21?
Mm-hmm.
There's a B.
There's a B on that page.
Okay, 7.06.04.
No, it's up at the top of the page.
No, 7.06.01 B.
Capital.
Okay, that's on 720 for me, so sorry.
Yeah. Not just for this section, but there could be an argument when you say 6 months. Is that 6 calendar months? Is it 6 months to the end of the month?
Yeah, that's defined in the front part of our.
Yeah, so, but what I'm saying is maybe we need to look at number of days and not months, is my thought.
Well, we define that, so let's
Maybe
just
we
make sure it's.
should define it
Here.
days and
I
not
don't-
months.
I don't prefer to define it differently in different parts of the code.
That's what I'm saying. It's not just in this section, but maybe we should look at it in all sections.
Well,
Because,
that's why we have a master definition. It's in the front, the document.
and maybe put this in the master definition, is what I'm saying. 180 days instead of 6 months. Because I could argue that 6 months really means 6 months to the end of the month. If somebody comes in on the 1st and gets the permit, when is their permit up? Well, if it's 180 days, I know when it's up. If it's 6 months, is it month for month, or is it day for day?
180 days sounds more clear, and just easier, so could we just make it, whenever we say 6 months, make it 180 days?
Yes, sir.
So I'm moving ahead, if there's any questions on the concurrency calculations. I'm on page 7-24.
Question on page, your red version, page 22. Down at the very bottom of the page, under for a sanitary sewer. 90% of the development's projected potable water demand not to exceed the total citywide usage.
Mhm.
Where did you get the figure for 90%?
That's common for, that's a practical, common number for sanitary sewer, knowing that all water that comes into a building isn't necessarily going out through the sanitary sewer. You're drinking some. You might be watering your lawn with some, so it's not 100% consumption from, 100% going out into the sanitary sewer that's potable water that's coming into the house.
I mean, some of it could be going into a swimming pool, the different
Yeah.
things like that, that's right.
Is the 0.473 million gallons, is that the total figure or the 90% figure?
That is the total figure,
Okay.
and that is the number in our agreement with Bay County. Any other questions?
So we're moving to 724.
Yes, so just as I mentioned earlier, we have a recreation level of level of service standard. That's in that chart in the top center of the page. That is not a statutory requirement. This is something that Mexico Beach elected to do with the comprehensive plan. So I'm just letting you know, that's one of the elective, along with roadways, that's one of the elective level services that we measure. On the next page, 7-25, and so I'm looking at the original document, not the blue line that you
Yep.
received today, so if my number is a little off, my reference would be a little off, but 7.06.06 annual report. This is a concurrency report that is currently supposed to be prepared annually and reported to the city council, which summarizes the available capacity of all the facilities and services that we provide. So just a little cleanup here. We did, as you might recall, update our capital improvement schedule in the comprehensive plan last year. So that should be something we look at every fall. The following page under 70700 platting's been deleted, as now that is something that is not a city council action. So, and then we come to 7.08.007800. And this is talking about a special master, which I don't believe you use. Do you?
Yeah, we got a special master hearing scheduled for the 18th.
Okay. So I might need to, we just want to make sure this is still accurate and how we follow that. I'm not familiar with how that works, so I did not make any new changes to this section. So now maybe I need to
Yeah.
go through this with you.
You did take something out that typically is the case, that the city attorney would represent the city in an appeal. That's down on record 47.08.02 definition.
Yes, I think there was, because in the paragraph prior it says, which will, well, the sentence prior, which will not be from the city attorney if a conflict exists, so that's why I took out that sentence, because if there's a conflict, then that can't happen.
Right. So typically, I didn't even know they were having a special magistrate hearing, so obviously I'm not gonna be here for that one. No conflict there.
Yeah, I just felt like it conflicted itself. It said, which shall not be from the city attorney if a conflict exists, so if we need to massage that a little bit. That's why I deleted it. if I can get you to read that, to make sure it still makes sense and it looks right. And if there's some changes that need to occur, then I can,
I guess my question is, why is all this discussion of a special master in the LDC and not in the code? Because it applies to all violations cited by the code enforcement.
Code enforcer is what I read.
Yeah.
Yeah.
So typically I would see that in the code,
not this code.
not in the LDC.
Right.
So maybe we could look at moving that to the code and
I'm
where
fine
we
with
go. Yeah.
Code of ordinances.
Yes.
And that's the end of that. Article, oh wait, let me make sure. Oh, sorry, I take that back. Again, if we want to talk about what should be moved to the Code of Ordinances, at the bottom of page 7-35, where it starts with Section 7.11.00, nuisances, unlawful accumulations and growths. I felt like that also was a citywide issue that does not really deal with land development.
Yeah, that's just, you're talking about the nuisance provisions there?
Mhm.
Yeah, that should really go. Do you have that in Word? So I can drop it in?
Yeah, I sent it to you this afternoon. That was the blue line copy.
Okay. Well, I just meant all this deletion you were making there.
It's in Word.
Okay.
So that brings us to 7.9.00 on the page, my page 7-42, which might be 7.43 on the blue line version. This is provisions for non-conforming uses, structures, and lots of record. Trying to differentiate that uses and structures are a different situation. So I separated those, knowing that a use is how a property is used. So a food truck on a piece of property could be the use of the property, but it's not a structure. Some sort of event space could be the use of a property, but there might not be a structure. But a structure is something that requires a building permit, and you're putting it on and has to follow setbacks, height limits, all those other things. So you might have a structure that was built prior to the adoption of this code that doesn't meet the height requirement or the setback requirement that we have today. That would be a non-conforming structure. So that's how we talk about structures or uses that were existing prior to the adoption of these regulations and how they can continue on until such point as they might be damaged or destroyed by 50% or more. That's the common percentage, and then what happens after that point. So the non-conforming uses section is the first portion that I parceled out from the non-conforming structures section, which is the next segment. Trying to define that with a sentence. A non-conforming use does not represent the structure on a parcel, but rather how the structures or land alone is utilized. So just making sure that we understand what the differences are. And then adding some parameters that apply to non-conforming uses. They can't constitute a threat to the general health, safety, or welfare. They cannot be increased or expanded. They can't be altered in a way that, they can be altered in a way that decreases the nonconformity, but then once it's decreased, it can't go back to what it was before to increase again. Putting in a time frame to show that if it's abandoned for a certain amount of time, and I guess here again we need to put in 180 days rather than 6 months, then it's lost its non-conforming status. And it has to comply with all the regulations of the code. Allows for change of ownership or other transfer or title. doesn't terminate that non-conforming status, and if it's converted somehow, in whole or in part to a conforming use, that portion of the non-conforming use also converted shall lose its non-conforming status. So that's talking about the use of the property. And then 70902 goes into the structure, and it's essentially the same parameters, but it's specific to a structure on the property.
I have a question here. Help me, Neil and Jack, I know you were here right after the hurricane. What, I thought, this was like 2019 when we were dealing with the immediately after effects. Didn't we say something about if a non-conforming structure was sold, that it had to then conform, or was it that something, if it was, I don't know, there was something in there that bothered me.
Does it have to be up to code? Is
Well,
that what you're thinking? No.
maybe, yeah, there was something that we did that didn't jive with, let's see, non-conforming, well, this is non-residential, that were in existence or used prior to the adoption of the amendment of this code may continue in perpetuity. Didn't we have something, I can't remember. Do you have any idea what I'm talking
I know
about?
that for a certain period of time, if the house was destroyed in the hurricane, they could build back in the same footprint.
That was,
That would
That was
have
3
been
years,
non-conforming due to setbacks.
okay, was that the only thing that we said? Because I just had something niggling in the back of my mind.
And I don't remember specifically, but there may have been something about if it was non-conforming but sold, it needed to conform after that, but I
Okay,
don't remember that.
that's what I was trying to think, and I can't remember. Do you have any recollection of that?
I was not here after the hurricane. So
Right.
I do.
Okay,
That was when we were working on the comprehensive plan, and we're going through that emergency hearing in February of 2019. And we added the clause in that policy to allow the build back in the footprint and what it was prior, because there were so many non-conforming structures in the city at the time, especially when it came to density. And that was then transferred into a regulation into the code, which subsequently Chris Truitt extended the time frame, not knowing that the time frame was also in the comprehensive plan, and didn't look at the comprehensive plan. So when I came back into more of a role here, I made him aware of that, so that we decided at that time that it would have to stop because the time frame was already passed in the comprehensive plan policy. So that plan policy, that LDR code provision has now been removed because that time frame has passed. We removed it a couple years ago when we did some updates to the LDC. But yes, it allowed you to go back in your footprint regardless of your density. Because
yeah.
And I don't think Lisa's questioning that part. It's-
No, I'm not questioning that part.
Transfer.
It's a
Yeah.
policy issue. Some jurisdictions, some governmental entities that I've represented over time have just said that from a policy standpoint, we're going to try to move everybody over time to the current code requirements, particularly on the structures. And from a policy standpoint, some do have a cutoff of the grandfathering, if you want to think of it that way, for either non-conforming uses or non-conforming structures upon a sale or transfer. Some jurisdictions, from a policy standpoint, they don't want to do that. They have the idea that you can just pass it down to your grandkids and it'll still be non-conforming. Even if it transfers, the deed transfers either by sale or by gift or however you want to do it. So That's really a policy. I don't know what Mexico Beach did after the hurricane. Laura spoke to that, but it is a policy concern and decision that some entities make to try to, in essence, move everybody to a current code.
So I can see how that's easily doable with a non-conforming use. But if you have a non-conforming structure, I don't know, I'd like to see how that works to make it
Yeah, it's primarily
conforming.
uses where you would
Yeah.
see that.
Because you can't
Yeah.
take a setback off or a height off of a house if
Yeah,
it's not,
yeah.
if
It's
it's not
primarily
conforming.
Okay. Thanks, I just,
But that's a policy. If that's a policy you all want to recommend, then you need to give us that direction, and then we can write it that way. If it's a policy you don't want to have, then I think Laura's got it written without that, so,
For use or structure?
for use.
I just knew that there was something there that we had said other than, you got 3 years to build back in the footprint. But I can't remember
Me either.
exactly what it was, so,
That's what,
and Jack.
unusual times.
Yes. So,
Yeah, there's an abandonment clause for a use, of 180 days. If it's not being used for 180 days, then anybody who reoccupies that use has to be conforming.
Okay.
is that enough?
Yeah, I think so.
Okay. Okay.
But it does, part E says a change of ownership or transfer of title
That's maybe what we're.
shall not terminate the non-conforming status of the use.
So, depending on
That's the
what you all
use.
want to recommend, then that would have to change if you want to try to cut off the non-conforming use and require it
I
to.
would think so. That's a mechanism for bringing it,
Into
Correct.
conformance.
Bringing it up to code.
yeah.
So for example, I'm not using anything specific, but if you had a residential dwelling that was being used for a retail purpose, and it wasn't allowed by the future land use map amendment or the zoning, and somebody decides to sell it, then the new person couldn't buy it as a commercial. It would have to be used residentially.
What would that mean for, there's a commercial location, it's a block or so this way of the coffee shop, and it has not been used since the hurricane. It's empty right now.
Well, then they've lost, whatever
It's
status
lost
they
its
have,
non-
they've lost it.
You know, it's lost its.
But I would,
You know what I'm talking about,
Grandfather
Mel? It's I mean, you can almost walk into the place.
Oh, the old,
It used to be a store, it was a.
yeah, it's a trailer that has been built onto, or no, it was an old, it was an
It's
old,
a building, it used to
old
be
building.
a store, but it's been.
Yes, yes,
It's never reopened, and I think the place right next to Mingo Marley's would be the same example, right? It has never reopened since the
right,
hurricane.
right.
Talking
Is it
about the one that
commercially
Mr.
zoned?
Tender used to own?
I don't know who owns it.
Yeah, Jeff Timmer was in there, yeah, for a while with his store for 10 years, yeah.
So that's certainly exceeded 180 days. That means that if it's reopened, it must conform to current
to the
standards.
use, yeah.
Correct, according to the way we're interpreting this?
So I would just make sure that there's no Bert Harris issue.
Yeah, I was gonna say, one of the things the city
That's
may wanna
good.
do is
Yeah,
when you get
exactly.
ready to enact this, you provide notice to the public. And that starts the Bert Harris timeframe running.
So how do we do that?
Well, I've done it in the past with a letter,
To the owner? Or just to the-
to any potential affected owner.
You'd have to determine nonconformities.
Yeah.
So,
So it would be the two buildings we mentioned, and there are probably others that they need to
Probably
receive
some.
notice that if you choose to, and they need to be doing something anyway.
Yeah.
Well, and it wouldn't be the ones that have lost their non-conforming status by virtue of being vacant. I mean, we're talking about, they're currently in a non-conforming use and they want to go sell that. So it'd be an ongoing kind of thing. You may want to give notice to the vacant people too, but primarily the ones that even under the current, the old code would not have lost their non-conforming status. Because I'm assuming that was in the old code.
So the old code says, or what I should say, the current code says that use is not legally permitted by this regulation, the 1991 Beach Land Development Code, or which did not pre-exist that code, shall be considered illegal. This section is to protect the rights of property owners, blah, 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 blah. Those non-conforming uses may continue in their present condition, but shall not be substantially enlarged, expanded, extended, or be allowed to add other uses or structures.
So they don't talk about the transfer of.
No, that's new. That's new. So if you are going to elect to remove the proposed Part E that talks about change of ownership or other transfer of title and real property on which a non-conforming use is located shall not terminate the non-conforming status of a use. If you decide to not include that, then you need to make sure your Bert Harris actions
Give the notice.
are, yeah.
Well, or include just the opposite of that section, a change of ownership shall cut off.
Well, even then, you're gonna have to do your Bart Harris
Yeah.
notice.
But that's a policy decision for you and the council to decide if that's really where you want to try to move the
But
city.
even if it's not a change in ownership, if they even wanna come back and do something, it's
If
gotta
if
be,
it's been, now, the 180 days or 6
still
months
gotta be brought up to
is
code.
also new.
Yeah.
It's also new. No, this stuff in here is new, so this would be, again, stuff the city would want to give notice to potential.
So even the 180 days is gonna require notice.
Yeah, that's,
So the 180 days would start at the notice date?
The 180 days would start from the enactment of the LDC, the new LDC.
okay. Where is it, and it may be completely separate than this, but in the abandoned building discussion that we're having right now, regardless of a person changing ownership, can it remain abandoned forever? And at what point does it become a hazard and dangerous if a piece of, because it hasn't been maintained, metal flies off and hits your neighbor's car, or an awning falls on a person at the place next to Mango Run? It's just because it hasn't been maintained. Do we have any mechanism?
There's a difference between being abandoned and not being maintained. It could be vacant and still maintained, it's in sound condition, it's not a harm. But if it's not maintained and it becomes a safety issue.
Yeah, if it's an unfit or unsafe structure because of hazards like that, or because it structurally it becomes unfit and unsafe, then there's a different mechanism for that, to deal with those. And those can ultimately even be required to be removed by a city. Because again, the focus of the city needs to be safety.
Yeah.
And so, you know, if you've got literally projectiles coming off of a building, you need to address
Yeah.
that. you know.
And I don't know if we do, but 8 years after a hurricane, if something has not been
Well, you have
addressed,
snakes and you have all kinds of stuff, you know.
Yeah. Oh, I think that we need to put something in here about,
I think the public would expect us to what are you doing about this?
yeah, because we often have questions at the council meetings about these buildings that are, everybody calls them abandoned. So we need to say something about abandoned, which are in dilapidated shape, and property that has been unused, like commercial properties, like that store you're talking about, like on 27th or 28th Street right there, yeah. So we need to put something in there.
Or it can be an old house in your neighborhood that nobody's lived in.
Yeah, but keep in
Just
mind that
Yeah.
if it's being maintained, it might sit there for, I mean, theoretically, you wouldn't allow it to do that from an owner standpoint, but as long as it's being maintained and there's not a hazard, it could be vacant.
And that's okay, a lot of homes are
Yeah.
vacant, I mean,
Right.
These are vacation homes, but who determines, if a city's charge is safety, who determines when it becomes unsafe?
Typically, that's the building official,
Okay.
is who would make that determination.
So in our case, it would be someone, an inspector from EPCI?
Correct.
Is that, so that, does that mean in their,
Fire chief.
Yeah, well, it could be the fire chief, but the building official traditionally is the one that would determine if it's unfit and unsafe. I don't know if there's a specific provision in your code that requires that of the building official, but that's typically who does it.
There it is. It's in, section 151.079, unsafe buildings, declared illegal in public uses,
Okay.
code of ordinances.
so right now, Mel, is that Greg and Willie or someone else?
It's Greg and or Willie, whoever's most qualified for whatever the problem is. And Greg's been out doing those things before.
Okay.
The city just got a claim that a building was unsafe, and it sent Greg out, and he did an inspection.
All right.
It just talks about it, the head of the enforcing division shall declare it unfit.
I do have a question, if you don't mind.
Mm-hmm.
Under the non-conforming structures, 70902, letter C1, it says if a building or structure has not been actively occupied for a period of greater than 6 months, then prior to reoccupation, the building or structure will be required to comply with the requirements of this code, including but not limited to the requirements relating to stormwater, height, density, intensity, setbacks, parking, et cetera, et cetera. So if you have a building that was non-conforming and they were in the setback, but they should not be,
I see where
can
you're
you
going.
move the building?
Well, it depends, but buildings are moved,
That
but
would be changed.
yeah, yeah. I would say some of that can be affected, like parking and open space.
Yeah, otherwise,
Landscape.
that is the cutoff of grandfathering for non-conforming structure,
Right.
and that's a harder sell to the
I would think so, yeah.
So we can still talk about stormwater, parking, open space, buffers, and landscaping.
Absolutely.
Yeah.
So let me get this straight, so if you have a vacation rental that's unoccupied for 6 months, and like, let's just say it was rebuilt in the same footprint after the storm, and so it's 3 feet into a setback. If it stays vacant for longer than 6 months, we're gonna have to move the house, or bring it up to the current standards, if it's not rented for 6 months.
Well, we're changing that section, so I think,
Well,
Laura,
just
you
because it's not rented for 6 months doesn't mean it's abandoned, though.
Yeah,
Well, it doesn't say, it says unoccupied.
has not been
Actively
activated.
occupied.
Yeah, we are deleting the height, density, and intensity setbacks portion of that.
Sounds like we also need to be clear on what is,
Actively occupied.
So some local governments will look at utility usage, whether or not it's even connected, to see whether or not it's abandoned.
Well, is it better to say abandoned than occupied?
Yes.
Okay.
Has been abandoned.
Cause I think that's, you could say that there's a rental and the air conditioner's been running for 6 months, that's not abandoned, it's just unoccupied.
Right.
And you may have a situation where they cut off the electricity,
Yeah.
and that clearly shows it's, abandoned. As a matter of fact, some jurisdictions have a provision that requires utilities to be active to a structure, or else it would be deemed abandoned. Some places, and I don't know if you have any here, Mel, but some places, they don't have an active water or sewer connection, but yet people are trying to live there.
That's a problem.
Yeah, that would be a big problem.
So I'll add a definition of abandoned also to the appendix.
So going back to what we were saying under E, change of ownership or other transfer of title in real property on which a non-conforming use is located shall not terminate the non-conforming status. What have we decided to do with that?
Is that the one you're gonna rewrite?
No, that's the one you were thinking you didn't like because you wanted to not allow that to occur.
I got the impression you all were saying to cut off the grandfathering upon a transfer
That's
of
correct.
the use.
I
Okay.
think that's,
Okay.
Well, so it's also in the structure section, so we have to decide use and structure or
Well, it
just
can't be
use?
in the structure section. I mean, we gave people the ability to build back in the same footprint. And so we're saying when they sell that house, they gotta tear it down. I mean,
Right,
it's gotta be use, not structure.
yeah, I
Yeah.
agree,
Yeah, so don't mirror it in the structure, so.
right. Any other questions on uses or structures? We can go to lots of record. This is it's partially an existing section of your code, and then I've added some language to help clarify and mimic what we've just really recently also adopted in policy to the comprehensive plan. So just to implement that policy that we adopted in the future land use element. So this is talking about lots of record on or recorded platted lots that might be non-conforming to today's standards based on density, because that's really how we measure our lot sizes here. We don't have minimum lot size requirements, just to allow them to have one dwelling unit, regardless of the density.
This is
requirement.
just mirroring the comp plan change that was made recently.
And then you have a new section. So there was your language about the 6 months that was stricken out. I just meant that one. The vested rights. So a vested right occurs when a final development order or permit is issued by the city, and the development order or permit has not expired, but laws have changed. So maybe right now, we're updating the land development code, and maybe somebody's got an active development order, but hasn't gotten the building permit yet, which starts the toll on the development order. If we adopted this tomorrow, because they have a vested right in that development order, whatever changes that are made that might affect their development do not apply to them because they have a vested right. They can continue on.
They have to have an active development order. Somebody that came in and got a development order 5 years ago, never continued it, never got it extended, will try to argue that they should have a vested right, but
How long is that for?
under this language, it would not.
How long is that vested right for?
Well, for the duration of the development permit, which can last 6 months,
Okay.
180 days.
As long as it's not expired.
So when you have your development order, but you haven't received any building permits or you haven't moved any ground, that's the period that we're talking about. So once you start developing your land or you receive a building permit, then that development order timeframe stops because you're now in the next phase.
We need to be consistent on development order and development permit. And if you're gonna have the defined, use the statutory development permit, then I think we should be consistent on it.
Yeah, the development permit is a development order in the statute. It's the same. They
Well,
treat it the
I
same.
would think we just be consistent on how we use it in here.
Well, yeah, let me know where I have it because I thought I had.
Yeah, I'm not saying that you have, maybe you can run a search and see
Yeah, I usually,
if you have the term.
development order or permit is usually how I phrase it. So are there questions on that section?
makes sense to me.
So Laura and I will get together on those two sections I have, and then she'll also do some rewrites on the rest, I assume, and maybe we can look at it one last time in April.
So since this was almost a working session of two recent collaborations, will the next meeting be to look at the final version of this, or will it be this plus more content?
It should be the final version, in my opinion.
Right, but he's asking.
So is the next meeting just this meeting part two?
No, there'll be other items on the agenda, yeah.
Okay, if that's the case, then it looks like we're ready for adjournment. Would anyone like to make a motion to adjourn?
So moved.
We have a motion,
Make a motion to
second, okay, we have a motion and a second, we're officially adjourned.
Mel, you stop playing